Renting a company op in New York. Renting a co-op in New York City comes with unique challenges that set it apart from renting a typical apartment. Unlike standard rentals, co-ops require board approval, which often involves an extensive application process, financial scrutiny, and even an interview. Understanding these steps is crucial before committing to a co-op lease. Since co-ops are structured as corporations where tenants own shares rather than individual units, renters must adhere to the co-op board's rules and regulations. These can include restrictions on subletting, renovations, and even guest policies. Working with a knowledgeable real estate attorney can provide the support you need to address and resolve any conflicts that may arise. Legal considerations when renting a company op. New York co-op laws allow cooperative boards to impose strict regulations on tenants. As a renter, you do not own shares in the co-op but lease the unit from a shareholder who must first obtain board approval to rent it out. This means board approval is mandatory. Prospective tenants must submit financial statements, references, and a formal application. Some co-ops also require an in-person interview. Leases may contain restrictions, rules about pets, noise levels, and guests can be stricter than in traditional rentals. Subletting policies vary. Some co-ops have limits on how often or for how long an apartment can be rented out. Security deposits and fees differ. County op rentals may require additional fees beyond standard rental deposits, including application and move-in fees. Given these complexities, consulting a real estate attorney can ensure you fully understand your lease terms and rights. What to expect when renting a company op in NYC? Renting a co-op is different from renting a condo or apartment in a standard rental building. Here's what tenants should prepare for. The application process is more detailed. County op boards typically require extensive documentation, including tax returns, bank statements, and employment verification. Board interviews are common. Unlike standard rentals, a prospective tenant may need to meet with the co-op board before approval. Approval can take time. The process can take weeks or even months, unlike standard rentals that may approve applications within days. Additional fees may apply. Beyond rent, tenants might pay move-in fees, sublet fees, or application processing fees. Understanding these factors can help renters avoid unexpected delays and costs. Owning versus renting a company op. Owning a co-op means purchasing shares in a cooperative corporation that owns the building. Shareholders have a say in building decisions, pay monthly maintenance fees, and must follow the co-op's rules. Renting, however, means leasing a unit from a shareholder. The tenant does not own shares or participate in board decisions but must still comply with the co-op's policies. While renting offers flexibility, it also means dealing with the board's approval process and potential restrictions. How a real estate attorney can help. Renting a co-op in New York City can be complicated, but working with an experienced real estate attorney can make the process easier. An attorney can review lease agreements to ensure tenant rights are protected, guide renters through the co-op board approval process, help resolve disputes with landlords or co-op boards. At Avenue Law Firm, our skilled co-op real estate attorneys can assist you in navigating the legal complexities of renting a co-op in New York. Contact us today at 212-729-4090 or visit 505 Park Avenue, Suite 202, New York, New York, 10022, United States for a consultation.